Good afternoon. We're on the record in CV 2025-06641. May I please have appearance of counsel? Starting with counsel for petitioner.
Good afternoon, Your Honor. It's a pleasure to be in your courtroom again. Gene Chavez on behalf of the petitioner.
Thank you. Mr. Chavez, your audio was not coming through well. Let me see if I can make a few adjustments here and see if the court monitor captured you. But from my perspective, let me turn things up. Will you state your appearance again?
Good afternoon, Your Honor. Gene Chavez appearing on behalf of the petitioner. It's a pleasure to be in your courtroom again.
Okay, that was much better. Thank you. We don't have counsel for the New Mexico Racing Commission on this matter. Was set for hearing at 2:15. It's 2:23. The Racing Commission did file a response. It was filed by Mr. Bustamante on August 1st. Richard Bustamante on August 1st. Have you heard from Mr. Bustamante, Mr. Chavez?
I have not, Your Honor.
I'm going to give him a call on the number where the response, number listed on the response, and see what's happening. So let's just give me a moment. Mr. Bustamante, this is Judge Ortega calling from the Second Judicial District Court. We are in hearing on the Jose Fabian Hernandez matter versus New Mexico Racing Commission case.
Yes, thank you, Judge, and my apologies. I don't recall getting a notice of hearing.
Well, we are in hearing, and the notice was served, looks like filed and e-served on August 7th, I believe, which was about 6 days after your response was filed. I checked with my TCAA, and whoever is doing your filing has not attached as a service contact to Tyler. So that might be the reason.
My sincere apologies to you, Judge, and the court, and to the parties. We did have our law clerk leave unexpectedly, so my sincere apologies, Judge.
All right. Are you prepared to have the hearing on the request for an emergency TRO and preliminary injunction?
Yes, as a matter of fact, what I'm looking for, Judge, in all honesty, is I'm looking for my argument template. So.
All right.
Yeah.
So I called you on my phone. Would you be able to connect to the hearing so that everybody's audio is connected to the same system and they can hear you and you can hear them?
Yes, I believe so. Is this being done through Zoom or?
It is through Zoom.
Okay. Yes, if somebody could send me the Zoom link, I can get on there right away.
Okay, I will have my TCAA do that, and then after this hearing, you're going to need to make sure that you're attached as a service contact in Tyler so that this does not happen again. All right?
Okay, yeah, my apologies again, Judge, to the court and to all the litigants.
All right, thank you. I'll have Michelle email that to you. It's Richard P. Bustamante at rcnm.gov.
Correct.
Okay, thank you. We'll do that.
Okay, thank you, Judge.
Thank you. Dominic, can you take care of that? All right. The email address is Richard P as in Paul Bustamante, Bustamante at rc.nm.gov. You're emailing him the Zoom link right now? Okay. All right, we're gonna, if you would mute your mics and cameras, I'm gonna do the same, and we're gonna give Mr. Bustamante a couple minutes.
Good afternoon. This is Richard Bustamante.
All right, we are back on the record. Will you please state your appearance, counsel, Mr. Bustamante?
Yes, good afternoon. This is Richard Bustamante on behalf of Respondent, the State of New Mexico Racing Commission.
Okay, thank you. Let me make sure that the court monitor captured your audio. She did. Okay, thank you. We are here on a petition for emergency temporary restraining order and preliminary injunction. This was filed by or on behalf of Mr. Hernandez on July 29th. There was a response filed. I did review the petition and the response, and I'm ready to hear argument. Mr. Chavez, if you would please begin, and if you wouldn't mind speaking slowly, just so we can capture a clear record. I know that you tend to talk fast, and it will help to have you slow down a bit.
Thank you, Your Honor.
Thanks.
Your Honor, this isn't the first time we've been in your courtroom on this case. The last time we had filed a temporary restraining order and preliminary injunction was pending the administrative hearing for the petitioner in this case, Mr. Hernandez. And at that point, you denied it, and we held the hearing. Excuse me. That was several years ago. The hearing was conducted, and the hearing officer gave a report. I think the hearing was in September of 2023, and the report came out September 29th of 2023, and that report indicated that a dismissal would be appropriate. So the next step would be for the commission to sign off and adopt the findings of its own hearing officer. However, that has not happened. Here in this matter, they've tabled it perpetually at every meeting, and they attempted to try and remand it, of which the Attorney General's office was not having it and did not sign off on a remand. So essentially what we have is a racing commission that doesn't like the ultimate opinion of the hearing officer, which is a dismissal and the release of any and all purses and allowing the horses to run, as well as the trainer to enjoy his license without any impunity whatsoever here. And so I also attached, in addition to the hearing officer's report that recommended the dismissal, the opinion from another district court judge in a case very similar, in which the Racing Commission didn't like a report or a finding of the hearing officer and did the same thing, of which we had to file a Rule 75 and go from there. Here, Rule 75 is not necessary because the dismissal was from the hearing officer himself. So I believe if you take a look at some of the rationale, and I know you've read it, so I'm not going to go into detail, but the rationale of Judge Butkus was you have an opportunity to bring back some new evidence or something to that effect in certain situations. However, you don't have the opportunity to change the ruling. And so this is the last resort here, Your Honor, because we've been waiting for Mr. Hernandez to use his license as well as enjoy the use or the running of his horses since he had the hearing pursuant to law. It was recommended dismissal, and yet we're still without remedy. So if the Racing Commission wants to continue to try and hold this up and subject themselves to possible civil liability, fantastic. But we're asking this court to step in and allow him to race and run and utilize his license without a bond until they make that final decision, which is just a mere formality.
All right, thank you, Mr. Chavez. First of all, you reminded me of a case that we had many years ago. I didn't realize it was this case. I didn't do the research on this one. I didn't realize that I had this particular party in front of me before. But if I denied the TRO at that time, it was because I found that there was an adequate remedy at law. And here we are all these years later after he pursued his remedy at law, and we're back here, and you're requesting essentially the same relief. You're asking for, if you can explain, like, I recognize hearing officer Fitzwater's recommendation that the matters, all of the matters be dismissed, and then the commission asking for a remand, and things are just sort of in limbo, what specific relief or order are you asking this court for? If you can just outline what the order would look like if your client had exactly the relief he is requesting.
Sure, Your Honor. At the time that I filed the initial one, it was because there was a pending, well, let me rephrase that. There was an administrative hearing that was going to occur, but we didn't have a date or time. And so I requested relief from the court if you would allow him to run his horses as well as enjoy his license, pending the outcome of the administrative hearing. That would be beneficial to him. And I went over all the requirements for the TRO. You denied it because there was some remedies in place, such as a stay from the Racing Commission, of which was denied. And ultimately, we went through the channels that the court said we were supposed to go to. So here we're waiting for just the formality of the Racing Commission to stamp off of their own hearing officer saying dismiss this case, dragging their feet. We have no other remedy right now. And so as a last resort, we're asking this court to come in. I would prepare the order and submit it to the court, as I have in a few other cases in which a TRO was granted. And that is that the trainer or owner would be able to run his horses and enjoy his license, subject to all the restrictions and limitations that his license would have, just like any other license holder, pending the Racing Commission's actually addressing this at a meeting. I believe this court also does have the power, as in some of my other cases in other jurisdictions, to give a time limit as to when that's to occur, because it's the administrative code is silent as to when that's supposed to happen. And so in other cases that I've dealt with, there was a restriction 60 or 90 days. This has to occur. I did file a TRO, preliminary injunction, which was ultimately denied. However, there was a requirement by that judge, Judge Ortega out of San Miguel County, said you need to have this administrative hearing within 90 days. And that did occur. But I know this court does have the ability to do that. So we would respectfully request that Mr. Hernandez be able to enjoy, and he has sold some of those horses. So I'm not going to mislead the court by saying that all these horses are going to be running, because I think they've been sold. But the ones that he has, as well as the use of his trainer's and or owner's license to be utilized in accordance with law, and a deadline put on the Racing Commission to adopt the findings of the hearing officer as contemplated in the administrative code within 60, we prefer 60 days because it's been 2 years. Essentially, it'll be 2 years next month. So for them to sit there, on this and not take any action because the administrative code of silence does scream for the court to come in, because there's no other remedy.
Okay, thank you. That helps a great deal to provide the background. The only other questions I have relate to the matters that were raised in the response, and that pertains to the action that is pending in the 12th Judicial District Court by Mr. Hernandez against the Racing Commission, a complaint for damages pursuant to the New Mexico Civil Rights Act. Why shouldn't that judge have this issue before? Why wasn't this filed in that case?
Well, that is a good question, Your Honor. I mean, I don't know. We filed because every month that we get the agenda for the Racing Commission, we're under the assumption that it's going to be heard and it's going to be dealt with. But unfortunately, the Racing Commission has not dealt with it at this time. If this court, denies it because of jurisdiction or wanting to defer to the pending case, that's fine. However, this court still has the ability to do that as well. The other court involves two different litigants, which is Mr. Mr. Martinez, who is the trainer, and I think I've said trainer on several occasions, so my mistake. The owner is separate, so there was separate counsel for both. I know that.
And your client's the owner, right? Mr. Hernandez is the owner?
That is correct.
Okay.
And so with separate entities and actions, the other thing I would advocate is, I believe that the trainer, which is Mr. Martinez, he dismissed his claims in the underlying action here in front of the New Mexico Racing Commission. So the only one that's pending is with Mr. Hernandez, and I think that's the only one that we're dealing with here. So I do think that this court would have jurisdiction, and I do think that filing a separate TRO would have absolutely no implication or any effect on the pendency of the active civil rights case.
Okay. All right, thank you. Anything else, Mr. Chavez, before we turn it over to Mr. Bustamante?
No, Your Honor, thank you.
All right, thank you. Mr. Bustamante, response?
All right. Thank you, Judge. And again, my apologies for the lateness to this hearing, to the court, the parties, and the court staff. Thank you, Judge, so much for the call and allowing me to participate. Judge, on behalf of the State of New Mexico Racing Commission, the first point I would make is essentially the point that you brought up just last is why should this have not been filed in the 12th Judicial District as part of the case that is pending down there? And as you see from the Commission's response, we believe that based on judicial economy, basically that in fact this matter should have been filed in that 12th Judicial District case. Even though there is an additional party in that civil rights case, all of the facts that are relevant to this matter essentially are facts that are relevant to the civil rights matter as well. So for judicial economy, we believe the proper course of action is to essentially dismiss this cause of action without prejudice, and then counsel can make the decision whether he wants to file this in the pending 12th Judicial District case. Now, turning to the
before we turn
Yeah.
to that, I want to ask specific questions about that. I certainly recognize judicial economy, but this court doesn't lack jurisdiction over this matter, and you're not making that argument, right?
No, the Commission definitely does not argue that this honorable court lacks jurisdiction. Our argument is simply just for judicial economy's sake, that there is a pending case involving Mr. Hernandez, and essentially in the 12th Judicial, and again, all of the facts relevant here essentially are basically before that court. So we feel that the appropriate avenue is that court.
Okay, thank you. And I'm sorry to
you're
interrupt.
welcome, Judge.
Yep.
Oh, no, that's okay. Just obviously it's your prerogative as the judge. So, Judge, turning to the responding to Mr. Chavez's arguments. First of all, let me clarify some of the facts here. Is that first of all, Commission Rule 15.2.1.9 B15F provides, quote, and this is regarding the Commission's response to hearing officer reports and recommendations. In response to a hearing officer report, quote, the Commission may adopt the proposal for decision in whole or in part, decline to adopt the proposal for decision in whole or in part, remand the proceeding for further examination by the same or different presiding hearing officer, or direct the presiding officer to give further consideration to the proceeding with or without reopening the hearing. So essentially, when the Commission considered the hearing officer's report to dismiss the matter, obviously they exercised their authority under that rule to remand it back. In order to complete the entire hearing, basically receive any additional evidence or argument, and then basically present a new hearing officer report and recommendations to the Commission. So what the Commission did was basically within its proper rule authority. Then what occurred is both Mr. Hernandez, represented by Mr. Chavez, and the other individual, they filed a civil rights claim, and they filed that in the 12th Judicial District. And again, that is case D202CV2025. Oh no, I'm sorry. It is D1226CV 2024-00015. So they filed a civil rights claim there seeking damages. Given the nature of that proceeding, we necessarily had to farm it out to a risk management assigned counsel. In the meantime, basically, once the hearing officer at the commission learned of that pending case at the 12th Judicial District, the hearing officer determined, I no longer have jurisdiction. Basically, given this pending appeal, our hearing officer read it as, I don't have the authority to take any action in this case whatsoever. And so therefore the hearing officer basically said, I am done here until that civil rights case is completed. So that is why no further action has taken place, because the hearing officer basically concluded that the filing of the civil rights action basically took his jurisdiction away. Plus, obviously, the hearing officer realized that he could not hear matters of constitutional importance. So that stopped the case here. Now, in the meantime, obviously that case was filed in 2024. I did have I've learned since then that essentially the case is basically in limbo. Pretty much to my knowledge, no discovery has taken place. So essentially, Mr. Hernandez is one of the plaintiffs, and the other person, they have not done anything to move this case forward. So essentially, consequently, the commission can take no action to either revive Mr. Hernandez's racing license. And so essentially that is why we have not taken any action to resolve the appeal before the hearing officer, because in light of the pending civil rights claim, which unfortunately the plaintiffs don't seem to be moving forward. So basically, Judge, it's the commission's argument that with all due respect, this matter is more properly before the court in the 12th Judicial District rather than here, basically. And so essentially we would ask basically that you deny the request for a TRO and preliminary injunction. First of all, let me proceed to address basically the merits of the TRO, which it appears, as you know, Judge, basically, first of all, there's the doctrine of exhausting administrative remedies. Clearly, Mr. Hernandez's administrative remedies have not been exhausted by him. He still has a pending appeal before the hearing officer here, which the commission will hear, basically. But of course, that is in limbo because they jumped over to the 12th and filed a civil rights claim. So essentially, plaintiff, by his own action, basically, he's failed to exhaust his administrative remedies, and therefore his application for a TRO and preliminary injunction should be denied. Under Grisham v. Romero, 2012, New Mexico Supreme Court 009, preliminary injunction is proper where the movement will suffer irreparable harm unless the injunction is granted. The threatened injury outweighs any damage to the injunction might cause the adversary. Issuance of the injunction will not be adverse to the public's interest, and there's a substantial likelihood movement will prevail on the merits. Well, Judge, basically, here's the situation is that Mr. Hernandez would like to get back the right to use his license by the commission, which is a privilege, not a right, in order to compete in horse racing. Judge, it is sheer speculation that if he gets his license back, that basically he will basically end up getting his income back that he's lost from racing. His horses may be scratched in the starting gate. They may get injured and not finish the race. They may run in a race, but not receive any purse. So it's mere speculation and conjecture that basically that if he gets his license back, that essentially that he's going to proceed to basically be able to basically he'll make use of his license. It's mere speculation and conjecture that that license is going to turn into an income for him. Regarding the matter of the threatened injury outweighs any damage, or excuse me, issuance of the injunction will not be adverse to the public's interest. Judge, with all due respect, the reason Mr. Hernandez was brought before the commission was basically based on a disciplinary measure where essentially he has several drug violations, drugging a horse, a totally innocent animal that is completely dependent on him for his livelihood, drugging a horse just to gain a competitive advantage for financial gain. That case is still pending. Our rules read that when the commission basically makes its case, that is prima facie evidence of a medication violation, and the consequences for that is a suspension of your license and a fine. For the owner, it's the having to turn the purses back. These were high dollar races, and it's multiple medication violations. So clearly, with all of those still pending and the commission having made a prima facie case that in fact these horses were improperly drugged, if Mr. Hernandez is allowed to get back in the game, clearly the public's interest is basically certainly going to be injured, because the public trusts that these races are run clean, that the horses are not drugged up, and essentially allowing this gentleman back into the game is going to cause those fans and the wagers of the sport to basically, how do I know this race isn't rigged? He has all those medication positives. So clearly, the public's interest in keeping a cheater out of the game is more important than allowing Mr. Hernandez to get back in the game, because essentially he gets back in the game. It's mere speculation and conjecture that he's going to make any money out of racing, basically. So essentially, Judge, if you look at the merits, basically, let me address the other. The threatened injury outweighs any damage the injunction might cause the adversary. Judge, the Racing Commission is statutorily charged with basically regulating the horse racing industry for the health and safety and welfare of the equine athlete, as well as for the benefit and trust of the fans and the wagering public. Clearly, Judge, I would respectfully submit that the commission's interests far outweigh basically Mr. Hernandez's interests, and those commission's interests are assuring the health and safety and welfare of those beautiful animals, and basically regulating the industry such that the public has a greater trust that in fact, when they're betting on those horses or they're enjoying watching races, that those horses aren't drugged up just to gain a competitive advantage and win. So essentially, Judge, on the merits of the TRO, essentially the plaintiff has failed to basically prevail on all of those elements, and all of those elements are necessary. So based on his failure to exhaust the administrative remedies, based on the fact that this case is more properly before the judge in the 12th Judicial District, and based on the fact that plaintiff would fail to meet the necessary elements for receiving a preliminary injunction or TRO, we respectfully ask that this request be denied. Thank you, Judge.
Thank you. Mr. Bustamante, I have some questions. One, the argument that the remand and the commissioner hasn't moved forward because of the complaint that was filed in the 12th. How do we know that? Is there something in writing in the record that you can point me to say, here's why the delay has occurred? Here's why this matter isn't going forward?
You know, Judge, I'm trying to, I believe that that in the 12th Judicial District, and I'm just trying to recall things, and I apologize if I misstate things. I believe that the judge in the 12th Judicial District entered some type of, the judge entered some type of filing that when it was presented to the hearing officer concluded, oh, I've deprived of jurisdiction here. I can't take any action. And I apologize, Judge. I cannot recall what that document was. But I know that when that was presented to the hearing officer, he concluded, I can't act in this case anymore. And because I can't act anymore, likewise, the commission can't act, because essentially they would be dependent on me to take some action, provide them with another recommendation, and I can't do that. And therefore, essentially, this case has been basically on hold rather than in limbo at the Racing Commission, basically, again, based on the actions of Mr. Hernandez and the other individual, basically jumping over to an entirely different district to file a civil rights claim while essentially their matter was still pending before, their appeal was still pending before the Racing Commission. I will also tell you that the other individual involved in that civil rights claim, they withdrew their appeal of the steward's ruling to the commission. So therefore, the only party basically that is still on the appeal of the steward ruling to the Racing Commission is in fact Mr. Hernandez.
All right. But, and I understand that there might have been a ruling from the judge in the 12th. But what I want to know is where in the record, whether it's in the record of, where can I find evidence that the commissioner said, my hands are tied now because of the 12th or because of an order that is pending in the 12th? Is there some minutes of the commission? Is there something that would put Mr. Hernandez on notice that, hey, commission isn't moving forward on its administrative procedures because of the because of the filing in the 12th?
And again, Judge, and my apologies, is Judge, right offhand, I cannot recall if there was anything specific in writing. If the court would like, and if the court would grant me some time, what I could do, Judge, is I could basically go back, basically kind of retrace the steps of that case, look at the various pleadings that were filed late in that appeal, as well as maybe look at the minutes of the commission hearings. And if you would allow me that time, I think I hopefully could locate if there is something, basically, and also notice to also regarding notice to Mr. Hernandez via his counsel. I apologize, Judge, that it has been such a passage of time. Again, based on the filing of the civil rights claim, I cannot recall right offhand what, if anything, on the record there is that would have advised the commission of that, or regarding how exactly Mr. Hernandez was advised of that. But if the court would indulge me to give me some time, I could locate that and see if I could provide that to the court as well as to Mr. Chavez.
All right. And then my other, I did look up the 12th, the case in the 12th, and it looks like it's set for trial. So looks like there's a scheduling order in place and it's set for trial in December of this year. So
that's right, Judge. I think the last time I looked, I did see a trial setting, but to my understanding is that, for instance, to my knowledge, we've received no type of discovery or anything of that nature that you would normally receive, basically when trial is set this short distance away.
Okay, and maybe the plaintiffs feel like they've got everything that they need and don't need discovery, but I don't think that case is stale. I think it's set for trial and um all right. I think I asked all the questions that I had for you, Mr. Bustamante. Thank you for that. Mr. Chavez, any rebuttal?
Thank you, Your Honor. Yes, the argument that a remand is appropriate is ridiculous in this matter because this case was not decided on the merits. And crying about what the horses are subject to and all this stuff really doesn't matter because this case was recommended to be dismissed for due process. And so a remand would do what? And I think that that was pretty clear with what the hearing officer said is this case took entirely way too long to even bring to fruition. So we're dealing with a situation here in which it took several years to get a hearing a hearing with the hearing officer. And then after the decision was made by the hearing officer, we're still waiting 2 years later for the rules to be applied. So to ask what is Mr. Hernandez, the owner of the horses, he hasn't exhausted administrative remedies. I don't know how that's not possible because he first tried to get a stay from the Racing Commission pending the the hearing officer's hearing. Well, that was denied. Okay, so we go forward, we do the hearing. The hearing officer recommends a dismissal. His only other remedy is to do what we're doing right now, and that is to ask the court to put a preliminary injunction in TRO and give a deadline to when the Racing Commission makes a decision. The administrative code that was referenced is referenced on page 6 of the ruling from Judge Butkus. And I'll read it from here. It says the administrative rules authorize the presiding officer to dismiss the proceedings, 15219C16. The court agrees with the petitioner that the commissioner's decision to remand the matter for a new hearing before a new hearing officer for the apparent reason stated above was arbitrary and capricious. We know that that's going to be found at some point in time. To try and remand it for a failure to hold the hearing within an appropriate time constituted a violation of due process. I mean, what would be the reasons? So let's take a look here. It says, although an agency has the power to remand a case to a hearing officer to obtain additional evidence on specified issues, an agency should not remand a matter for inclusion in the record of evidence unless the evidence could not have been introduced at the initial hearing in the exercise of reasonable diligence or the evidence was improperly excluded at the initial hearing. Judge Butkus referenced this. This is from the Second American Journal, Second Admin Law. As I said, it's the bottom of page 6. We're not dealing with a situation in which new evidence is to be introduced here. We're not dealing with a situation in which there wasn't the proper witnesses. We're not dealing with the evidence, the kind of case where it was any type of thing that was not introduced or should have been introduced or was neglected or anything like that. This was dismissed procedurally. So I don't know that this would fall under any exception on the administrative rules of, oh, the Racing Commission would have the opportunity to remand this in the event a hearing officer dismisses this procedurally, because I don't think there's any kind of remedy when it's dismissed for not meeting the proper procedure. And that's what happened here. So in accordance and in line with the reasoning and rationale provided by Judge Butkus previously on a case in which the Racing Commission didn't take action to remand, we're going to ask that one of two things, or both, to be honest with you. One is that this court grant the preliminary injunction and the temporary restraining order and allow Mr. Hernandez to enjoy his license and run his horses without a bond, subject to the same restrictions that any other license holder would have. Two would be a requirement that the Racing Commission get this in front of the on the agenda and have it heard to adopt or reject, and they can reject it, that's fine, but it's not going back to the merits. I mean, this is not a case that was decided on the merits. It was decided on procedural. So essentially, everything that Mr. Bustamante said is asking anyone who will listen to him for a second bite at the apple, and that's simply not going to happen procedurally. So In the alternative, if the court doesn't feel that a TRO, preliminary injunction, is appropriate, which we believe it is, given the passage of time and the lack of any other remedies, grant our preliminary injunction, our TRO, or require that the Racing Commission within 60 days get this on the agenda, have it heard, and make their decision so we can see exactly why they feel it's going to be remanded. And I've never seen anything from the hearing officer Fitzwater indicating that he doesn't have jurisdiction to hear anything, because I think that would have been, to remand to him on something that was decided procedurally would just is nonsensical. I mean, what is he going to say? Oh, oops, I guess I was wrong on this. He was very detailed in his analysis, and I supplied that as Exhibit A. So I think at this point, given the reason, the basis for this dismissal is not on the merits, it was on procedure. I don't think that there's any type of remand that would give the Racing Commission any relief that was contemplated in the administrative code. And I think that it's proper for this court to exercise this jurisdiction, regardless of what's going on in a pending case here, and grant the TRO or a timeline for the Racing Commission to make a decision.
And
All right.
Judge, might I have the opportunity to respond?
Briefly.
All right. Judge, first of all, let me clarify that essentially these multiple cases of drugging a horse for financial gain
I'm going to
all
object to this,
occurred.
Your Honor. It was dismissed. I mean, it didn't go into the merits. There was no findings.
Yeah, we're not going to go into the merits, Mr. Bustamante.
Okay. I'm just, okay, I apologize, Judge. Judge, all of these events occurred in terms of the races and the post-race testing. They all occurred pre-COVID, pre-pandemic. As you know, Judge, and I hate to relive it, obviously when COVID hit big time, literally the world sort of stopped. So therefore, for a significant period of time, just like the court did not hear things, the Racing Commission also had to basically put literally all business on pause. So that contributed a fair amount to the delay in getting the appeal from the Stewart ruling heard before our hearing officer. Then, Judge, the record will show that both Mr. Hernandez as well as the other gentleman in the case, they basically objected several times to hearing dates that were set before the hearing officer, and that certainly contributed to the delay. So a worldwide, once-in-a-100-year pandemic, and then Mr. Hernandez and the other licensee continuing the case, not being able to make certain proceedings and things of that nature contributed to the case. As I mentioned before, Judge, the rules do allow the commission the opportunity to remand a case back to the hearing officer. And again, the idea is we've heard your arguments regarding, or we've heard your recommendation, hearing officer, regarding the due process argument. And essentially, the remand was, please go back, hear out the entire merits of the case, and then present basically a recommendation that deals, and if you want to make your recommendation again on due process, I believe Judge Fitzwater could have done that, but also provide a recommendation and a report that deals with the merits of the case, meaning the medication violations, as well as the due process. So essentially, this was not a matter of the commission dragging its feet to get this heard.
I'm going to object at this point. The hearing officer already addressed these issues in his report.
All right. Anything else, Mr. Bustamante?
No, Judge, just basically, I just want to reiterate, the commission, through its rules, has the ability to remand back for further proceedings. And again, the commission didn't drag its feet in setting this, a worldwide pandemic, and Mr. Hernandez and the other gentlemen's inability to make set hearings several times caused the delay. And then, of course, the parties ran filed the civil rights claim, which of course basically stopped the proceedings at the administrative level. Thank you, Judge.
All right, thank you. Couple of things. One, I did look at the remand, and it says, rather than adopt the hearing officer report and recommendation, the commission unanimously voted to remand the matter back to the hearing officer for further proceedings. There's no other explanation for that, or what they're actually asking the hearing officer to do. But the hearing officer was very specific in his report, and he did absolutely consider the COVID pandemic. And specifically, the hearing officer stated the prosecuting attorney argues that circumstances such as the late COVID pandemic and the complexity of the number of samples justify the delay that occurred, and that respondents made no effort to speed the scheduling along. And the hearing officer, in this hearing officer's opinion, these fail. So the hearing officer considered all of that and found that those arguments failed. So the hearing officer addressed all of that. I went back and looked to see what orders were entered in the 12th that could possibly have put the commission on hold, and Judge Jessen in the 12th ordered that the commission shall restore Mr. Martinez's training license subject to the applicable rules and regulations during the pendency of this matter. So her order doesn't reference anything related to Mr. Hernandez, and the order, as I read it, doesn't say the racing commission or the hearing officer loses jurisdiction or shouldn't act. The order, as I read it, allows the trainer, Mr. Martinez, to proceed with his training. So perhaps there's another order out there. I didn't find it, but I don't see that order prevents or deprives the hearing officer of authority to take action on the remand. And at this point, I'm going to grant the temporary restraining order and preliminary injunction that is requested by Mr. Hernandez. It will be issued without a bond. I'm denying the request to require the Racing Commission to take its action within a period of time. The restraining order and the preliminary injunction will allow Mr. Hernandez to act in accordance with his license pending the appeal. And so I will sign the preliminary TRO and preliminary injunction. Mr. Chavez, if you would please send the form of order and injunction to the court's proposed text for Division 13. I'll get it signed and turned around. If you and Mr. Bustamante cannot agree to the form of order, Mr. Bustamante, please provide a competing form of order to Mr. Chavez, and then Mr. Chavez, please send the competing forms of order to the court's proposed text for Division 13. Please refrain from explaining why your form of order is right and counsel's is wrong. Please refrain from replying to all. Please refrain from any argument in the proposed text. It should simply be sending the proposed orders without any explanation, and I will review hopefully the agreed form of order, or I'll review the competing forms of order, and I will get one signed and turned around as soon as possible. Mr. Chavez, how much time will you need to get that form of order ready to go? Is a week enough? 7 days?
No, Your Honor, I can have it done by Friday.
Okay, excellent. I'll look forward to it within 7 days. If it comes earlier than that, that is excellent. Anything else we can address today, Mr. Chavez?
Nothing from the petitioner's perspective.
All right, Mr. Bustamante?
No, thank you, Judge.
All right, please make sure that your staff gets you as a service contact on this case and all the other cases, because I think the worst nightmare that I have is missing hearings, and I know what it's like to get a call from a judge saying, where are you? And so you want to avoid that. So please ask them to look at all your cases, and you all have a good afternoon.
Thank you, Your Honor.
Thank you, Judge.
Thank you.